Hi students, I am Professor Kshitij Bansal. I teach law at Jindal Global Law School. We are going to discuss the topic of property rights for farmers, African and Bangladesh legislations today. What will you be learning after listening to this briefing? You would be able to find out how the space left by CBD, Convention on Biodiversity, could be utilized to transform the comparatively loose concepts like the prior informed consent and benefit sharing into a solid property right. They will also be able to explain to you the Indian Biological Diversity Act with these legislations and find out how poorly our legislation is drafted as far as farmers' rights are concerned. It was seen in the context of Convention on Biodiversity, which I would be referring to as CBD, as to the two concepts which were developed therein. They are obtaining of prior informed consent and benefit sharing. Actually, both these are possible only when the farmers have some right over the plant genetic resource which they have developed. As is common knowledge, a person's approval of consent is asked for before entering into a premise when he is the owner of that property, or at least when he is in possession of it. Thus, while recognizing a prior informed consent concept, CBD makes it clear that a property right can be given to the farmers over the PGR. But the problem is the identification of these farmers, especially when it comes to traditional plant varieties. It is in this context that two legislations assume importance and can even act as a model for India to redraft its Biological Diversity Act. These legislations are Biodiversity and Community Protection Act of Bangladesh, an African model legislation for the protection of the rights of local communities, farmers, and access to biological resources. Along with these legislations, another important piece of document is Thammasat Resolution. Let us first talk about Biodiversity and Community Knowledge Protection Act of Bangladesh. The main provisions of this act give the farming communities property rights over the resources on which they depend for their livelihood. The following provisions of the act may be noted as: the state will recognize the original rights of indigenous and local communities, farming and fishing communities, and other communities that are directly linked through their livelihood practices to particular ecosystems and to the related knowledge, innovation, and culture specific to that livelihood. These rights will be considered inviolable due to the role of these communities as custodians and stewards, thereby establishing their primary and residual title over the resources, remaining aware of the rights of women in particular to the formal or informal communal systems of innovation through which they produce, select, improve, and breed a diversity of crop, fish, poultry, and livestock varieties. The plant varieties, microorganisms, fish and aquatic life forms, livestock, traditional medicines, agricultural practices and devices, and technologies produced through these systems, the human genetic diversity, all species and varieties of life forms and genetic resources, covering the whole range of biological diversity of all genera and species, including microorganisms and any other life form not explicitly included above. In determining the access and use rights of the communities, the rights of the residual title holders will prevail over the other communities. The state shall recognize, establish, and protect the rights of communities to collectively benefit from their knowledge, innovations, and practices acquired through generations, past, present, and future, and to receive compensation for the conservation of biological and genetic resource in accordance with the provisions of this Act and subsequent regulations, as well as in accordance with the rights and obligations enshrined in the Convention on Biological Diversity. The sovereignty of the state over the biological and genetic resources and the related intellectual and cultural knowledge and practices will always be given effect through the communities. The state, but only through communities, shall at all time and in perpetuity be the lawful and sole owners, custodians and stewards of biological resources, knowledge and innovation related to these resources. No biological or genetic resource and no intellectual and cultural knowledge and practices related to them as well as innovations arising out of them shall be sold, assigned, transferred or dealt with in any way whereby the status of the communities as the common owners, custodians and stewards of the resource or the innovation or the integrity of the resource or the innovation is impaired. The biological and genetic resources and the intellectual and cultural knowledge and practices as well as any innovations arising from these shall not be sold, assigned, transferred or dealt in any manner without explicit prior informed consent and effective participation of the communities concerned. The communities will always have the right to refuse transaction based on gainful intent or any commercial utilization, exploitation and exchange. The state shall ensure that at least a defined percentage of benefits, not less than 50% of the net monetary gain obtained from a direct or indirect commercial use of biological and genetic resources in which the communities are the common owners, sole custodian and stewards, be paid to the concerned local community or the group constituted as a community. Thus, these provisions cover both aspects of CBD called the prior informed consent and benefit sharing. Regarding prior informed consent, the provisions are much more stronger and effective as they are given the right to refuse access to the resources they maintained, which is not the case in our Indian legislation. In the case of benefit sharing also, there is a more than 50% of share to be given to the community. Let us now talk about African model legislation for the protection of the rights of local communities, farmers and access to biological resources. Section 5 of this model legislation goes as follows. Any access to biological resources, knowledge and or technologies of local communities shall be subject to written prior informed consent of the national competent authority as well as that of the concerned local communities, ensuring that women are also involved in decision making. Any access carried out without the prior informed consent of the state and the concerned local community or communities shall be deemed to be invalid and shall be subject to the penalties provided in this legislation or any other legislation that deals with access to biological resources. The national competent authority shall consult with the local community or communities in order to ascertain that their consent is sought and granted. Any access granted without consultation with the concerned community or communities shall be deemed to be invalid and in violation of the principle and requirement for prior informed consent as required under this Article 17. Any access to a biological resource, innovation, practice, knowledge or technology shall be subject to the prior informed consent of the concerned community or communities, ensuring that women fully and equally participate in this decision making. Local communities have the right to refuse access to their biological resources, innovations, practices, knowledge and other technologies where such access will be detrimental to the integrity of their natural or cultural heritage. Local communities shall have the right to withdraw consent or place registrations on the activities relating to access where such activities are likely to be detrimental to their socio-economic life or their natural or cultural heritage. What about property rights under these legislations? Let us first know about the Bangladesh Act. This act purports that the state recognizes the rights of communities over the following: their biological resources, the right to collectively benefit from the use of their biological resources, their innovations, practices, knowledge and technologies acquired through generations, the right to collectively benefit from the utilization of their innovations, practices, knowledge and technologies, their rights to use their innovations, practices, knowledge and technologies in the conservation and sustainable use of biological diversity, the exercise of collective rights as legitimate custodians and users of their biological diversity. Apart from these rights over the biological resources given under this Bangladesh Act, the community is given intellectual rights as well. Even without any formal registration, this right is recognized. Apart from the community rights, there is a category of rights devoted exclusively for farmers. Farmers' rights under the African Union legislation. The Act has created a unique way of entailing property right to the farmers for their traditional varieties as well as newly developed varieties in the following manner. Section 25, Clause 1 of the model legislation says, farmers' varieties and breeds are recognized and shall be protected under the rules of practice as found in and recognized by the customary practices and laws of the concerned local farming communities, whether such laws are written or not. Secondly, a variety with specific attributes identified by a community shall be granted intellectual protection through a variety certificate which does not have to meet the criteria of distinction, uniformity, and stability. This variety certificate entitles the community to have the exclusive rights to multiply, cultivate, use or sell the variety or to license its use without prejudice to the farmers' rights set out in this law. Farmers' rights include the protection of their traditional knowledge relating to plant and animal genetic resources, the right to obtain an equitable share of benefits arising out of the use of plant and animal genetic resources, to participate in making decisions, including at the national level on matters related to the conservation and sustainable use of plant and animal genetic resources, to save, use, exchange and sell farm-saved seed propagating material of farmers' varieties, to use a new breeder's variety protected under this law to develop farmers' varieties, including material obtained from gene banks or plant genetic resource centers, and to collectively save, use, multiply and process farm-saved seed of protected varieties. As mentioned in the beginning, we would also pay attention to another important, very knowledgeable document, Thammasat Declaration. 45 representatives of indigenous, peasant, non-governmental, academic and governmental organizations from 19 countries came together on December 1st to 6th in 1997 at Thammasat campus outside Bangkok, Thailand for an international seminar on sui generis rights co-organized by BioThai and GRAIN. They met to study, assess and develop their response to the increasing privatization of biodiversity and local knowledge, especially as driven by the trade-related intellectual property rights, TRIPS agreement of the World Trade Organization and resulting legislation at the regional and national levels. They focused in particular on the sui generis rights option for intellectual property over plant varieties as imposed on all WTO member states by the TRIPS agreement, as well as on other international agreements related to biodiversity such as the Convention on Biological Diversity. In Thai, Thammasat means knowledge of nature. It also means justice. Indigenous people, farmers and local communities have over millennia nurtured and developed the biodiversity on which humanity today depends. They have been wisely using their knowledge of nature to create sustainable food and health systems based on sharing their knowledge and biodiversity with others over generations and generations. Such community systems are being destroyed by economic development under the guise of free trade, green revolution, agriculture and the new biotechnologies, our globalization. They are also being destroyed by the rampant pirating and monopolization of biodiversity and related knowledge through the extension of intellectual property rights to life forms. Thammasat Declaration also was worried that no country exemplifies their concerns about WTO enshrined globalization as the host country, Bangkok, which means Thailand. The declaration further holds that the WTO TRIPS agreement obliges developing countries to provide some form of IPR on plant varieties by the year 2000. This may be done by patents or by some sui generis rights system, meaning, in Latin, system of its own kind. In 1999, 1 year before implementation in the developing countries of the TRIPS agreement, this provision will be reviewed, and we are preparing ourselves for this review, said this declaration. The main theme of the resolution can be seen in the following provisions. Our understanding of sui generis rights regime in TRIPS, the overall implication of TRIPS, and for that matter the whole of the WTO, is highly detrimental to people's economies, cultures and livelihoods. The sui generis provision of TRIPS gives WTO member states room to develop their own kinds of IPR protection for plant varieties, and many nations are now changing their national IPR laws. While some people look at the sui generis option in TRIPS as a window through which other forms of rights over biodiversity can be articulated in national legislations, it is our conviction that such rights will be linked to IPR and will result in new and further monopolization rights over plant varieties. The same is true of any sui generis rights option which could be developed and proposed under the TRIPS agreements for local and indigenous knowledge. The reaffirmation of our sui generis rights, sui generis perfectly describes the rights and systems we are struggling to defend, our own kind of rights and systems. We recognize our sui generis rights to exist independently of the IPR-based sui generis systems promoted by the TRIPS agreement. Our rights are inalienable. They existed long before IPR regimes came into existence. As legal, political, economic, social and cultural rights, they are part of people's sovereignty and therefore part of human rights. As community collective rights, they are indivisible and intergenerational. They include farmers' rights and apply to indigenous people, peasants and family farmers, fisherfolk and other local communities which derive their livelihoods from biodiversity. Their place and expression is firstly at the local level, but they must also be recognized and guaranteed at the national and international levels. The rights that we are struggling to develop, defend and let flourish should never be misinterpreted as or denatured into intellectual property rights. Because people's rights are under tremendous threat, we see the promotion of such rights also as a tool for resistance against and the rolling back of the forces of monopoly. It is on this basis that we will actively engage our societies from the village level through to our government in capitals to take part in the struggle for our sui generis rights, and on to the international level to oppose IPR regimes on all forms of life. This implies a whole range of information, research campaign and coalition building activities over the long term. Some of the immediate tasks at hand are to demand the revision of TRIPS in order to allow countries to exclude life forms and biodiversity related knowledge from IPR monopolies under the jurisdiction of the World Trade Organization, reinforce the defense mechanisms of local communities who are highly vulnerable to unbridled bioprospecting and to the introduction of genetically engineered organisms, support any calls by local communities for a moratorium on bioprospecting and demand an immediate moratorium on the research, development, release and transboundary movement of genetically engineered organisms. Assert the primacy of international agreements on biodiversity such as the Convention on Biodiversity and Food and Agricultural Organization instruments over and above TRIPS and other trade regimes for the resolution of these issues. Reaffirm the original intent of the CBD for the conservation and sustainable use of biodiversity and prevent the CBD from becoming a mechanism for transnational corporations to trade in biodiversity in the name of access and benefit sharing. Mobilize a strong global movement engaging environmental, trade, agriculture, consumer, labor, health, food, security, women and human rights, and all people's organizations in these campaigns. In the spirit of justice and embracing all knowledge of the nature and mankind, we commit ourselves to the Thammasat Action Plan and invite other organizations, movements, and people to join us in the struggle to achieve this vision. Thus, this declaration, which is just a declaration emphasized on the farmers' rights over the rights of the persons who seek access to their biological resources. After discussing Thammasat Declaration as the third instrument we could learn from for our Indian legislation to be improved, we can conclude by saying that these legislations show the scope of development in farmers' rights in many respects. These legislations make PIC and benefit sharing as the rights of farmers. Apart from this, the farmers are also given property rights like that of the plant biological resources of various varieties and property rights over plant genetic resources and traditional knowledge. This comparison is made just to show the desperate way in which BDA is drafted in India in spite of a very high level of scope for creating solid rights for farmers. These two legislations point to the fact that being a party to CBD can mean to have a legislation with more rights to farmers and those who hold biological resources than what is envisaged under the CBD. The Indian Act, on the contrary, has created a poor legislation out of CBD with no rights to the indigenous people or local communities like the farmers. However, it is not too late for India to opt for better. These legislations and its own experiences will definitely guide India for further looking at Biodiversity Act. So this module concludes that due to the above mentioned problems, BDA requires a substantial revision. This revision needs restructuring the enforcement machinery, revitalizing the principles of PIC, that is prior informed consent and benefit sharing, into rights to identify the farmers who conserve, preserve and develop the plant genetic resource in food and agriculture and traditional knowledge of protected varieties. I hope this was interesting and you've been made more curious to know further on these topics. Thank you for listening.